Okay, I'm Rachel. I'm from the Birth Trauma Association. I'm the Birth BTA's chair, and I'm delighted to be here with Maria today. Maria Repanos is from Hudgell's Clinical Negligence team. You're the head of clinical negligence there, and she has kindly agreed to answer some of your questions for you today. This was meant to be an Instagram live, but technology let us down. So if anyone has any further questions, please feel free to submit them via email to the BTA. But Maria, thank you so much. We've had so many questions come in. If we could just start, would that be okay with you?
Yeah, of course. Thank you for having me, Rachel.
It's a pleasure. I'm so grateful to you for doing this. So, the first question we've received is, what if the evidence for your case doesn't exist in hospital notes? Using as an example, my youngest child's birth at 29 weeks gestation. The unit was so understaffed that I shared a midwife with another pregnant woman who was also high risk and very ill. We both birthed at the same time, and the notes were all written retrospectively. I did a debrief session a week later, but the file didn't contain any of the real details, just a skeleton list of basics. My son has complex disabilities as a result of poor care throughout pregnancy, birth, the neonatal unit, and beyond. And I also sustain life-changing physical injuries and complex PTSD from it all. We've moved district and have better healthcare here, but I've had to give up my business, my career, my home, and my marriage has broken down in the wake of what happened. What a terrible story.
Yeah, I'm so sorry to hear this from whoever has sent in this question to you, Rachel. I think, first of all, I think obviously this is a very complex case. And in the first instance, what I would say is I would strongly suggest that this lady does seek some advice from a solicitor. I think in terms of what she has said in relation to her records and issues relating to her records and whether there are records that are missing or that were inaccurate. First of all, I'd suggest that she obtain her notes in the first instance, or does that via a firm of solicitors. And if she can see that there are inaccuracies or incomplete details relating to those notes, this is before she contemplates any kind of clinical negligence claim, then I would suggest that she puts a request in writing in terms of what those inaccuracies are, and that as an incident would be reported to the information governance lead and to the CQC, and they can review whether there are issues that are factually inaccurate, whether incorrect diagnosis have been given, and it would just detail any of the sort of factual disputes that might have arisen. In terms of the actual debrief session, I would strongly suggest that this lady goes back to the relevant trust to put forward her version of events in terms of the relevant details. But I think in terms of the types of individuals that we help in terms of any complaints process, I'd strongly suggest that she gets some assistance in relation to that and at looking at any inaccuracies with the medical records before she contemplates any kind of possible litigation.
I agree with that. I took out a medical negligence claim, and my notes were not an accurate reflection of the treatment I received. And it took a protracted process, but we were able to prove this via a medical expert. And so she went through my notes and was able to say what did happen and didn't. And it can be unpicked, even though it can be a protracted process. So thank you so much. That's great advice.
I know that's fine. And I think in those situations, for example, if a claim progresses, the individual has an opportunity to provide a witness statement where they give their version of events, and even if it doesn't tally with what's in the notes, this lady can state, I disagree with what's contained in my medical records on X date, and this is why I disagree with it. So there are always opportunities, I think, to contest issues like that, whether it's in a case or whether it's within the remit of a complaint.
That's brilliant. May I ask if there is any time limit on this?
In terms of bringing a claim? In terms of bringing a claim, there are legal time limits that apply for all clinical negligence claims. So for an adult with capacity bringing a claim, their time limit for doing so is 3 years from the date of the Negligent Act, or 3 years from the date when they became aware that they had reason to complain about treatment. Where the treatment relates to a child, they have until the child turns 21 years old. And if if an individual, whether it's an adult or a child, has no capacity, no mental capacity at all, then that rule in terms of limitation is disapplied.
Brilliant. Thank you so much. That's such useful information. We have, excuse me, we do have another question, and that is, why is mental health not classed, excuse me, as medical negligence? I've been diagnosed with PTSD because of traumatic birth, but solicitors say they can't help because it's not physical. They caused it, so I don't see how it's not negligent.
Well, I think this is quite difficult here, and certainly it's unpalatable for a whole variety of reasons. But medical negligence claims generally can be brought in relation to a psychiatric condition, but that has to have been caused typically as a result of negligent medical treatment where there's been a physical injury. So if the management of the labour and delivery itself, for example, is deemed to satisfy the legal test where inappropriate treatments led to a physical and psychological injury, then an individual can bring a claim in relation to that. But in this case, if the birth was traumatic because of the circumstances, but if the treatment itself was potentially non-negligent, then I'm afraid she wouldn't be able to bring a claim. So I think because we don't have all of the facts here relating to what's happened to this lady, it would be useful probably if she sought some advice to see whether there was any issue that's caused any kind of physical injury in terms of things that have gone wrong that have then led to her developing PTSD.
Mm-hmm. That's a question that gets asked a lot through the BTA. Yes, my treatment was okay, but I've been left with PTSD. And I suppose you're absolutely right. Each individual case is different, and it would be a case of seeking advice. And something that crops up again and again in our inquiries is, why can one not demand untruthful and degrading notes made by healthcare professionals be removed from the record with an annotation? You know,
Well, I think, as we discussed before with that other case, all individuals are entitled to have personal data rectified and deleted if it's inaccurate. So in those scenarios, whoever has sent in this query, I'd strongly recommend that they make a request and put that in writing about having those notes removed and to explain why. So in that type of letter, I would suggest that they explain why they're inaccurate, why they want them to be removed, and to await a response. If they have difficulty with that, again, to seek advice from a solicitor, but they certainly can do that. That isn't prohibited at all, and they have got the right to request that those notes are removed.
And who would they write to?
In that scenario, so if it related to an NHS trust where they were hospital notes, I would write direct to the trust. I would probably in that instance mark it for the attention of the legal services department of that hospital.
That's great. Thank you so much. Our next question is, why is mental health assessment not statutory to be made following birth trauma?
I think whilst it isn't a statutory requirement, sadly, because there are so many reasons why these mental health assessments should be carried out. In light of the recent birth trauma APPG, the report's made recommendations for 6-week checks post-delivery with a GP for all mothers relating to physical and mental health. So I think whilst it isn't the case now, hopefully this will be a positive step that comes to fruition quite soon.
I really think it needs to, because there's a dearth of healthcare professionals. Those 6-week checks, even though they're recommended, they're not always being made, unfortunately. And that is just down to workforce issues. I think in one area of the Northwest, there's only 3 health visitors for 60,000 people or something. So it's extremely challenging for the staff as well as the people who are missing out on the treatment that they so desperately need.
I think that's absolutely right, and hopefully with some further investment in maternity services and primary care services, those changes will be made, because I think they're absolutely vital, and especially in that period after a woman's given birth.
It's such a vulnerable time, and it's imperative, and it needs to happen immediately. It's not just something that can be rolled up 5 years. We need to really address this.
I think that's right.
Yeah, it's a very specific one, and it's, do I have a medical negligence case? And this lady has said, I gave birth in Cyprus and developed multiple fistulas from a midline episiotomy. This resulted in me needing a temporary colostomy bag and a rectovaginal operation. Everything is still ongoing. I still have the bag, and I'm currently ongoing treatment for another fistula found. Can I take this further or not? My heart goes out to this lady.
What a really, really sad case. I think in terms of from a legal perspective, I think without understanding the full circumstances surrounding the labour and delivery and the sort of sequence of events, it would be difficult to advise whether there's a potential claim, because a fistula can occur as a result of a non-negligent complication, but it can also result from poor surgical technique, which can be negligent. So I think in this instance, I'd recommend that she seeks advice from a firm specialising in clinical negligence, and specifically from a lawyer who deals with obstetric claims. It would also, I think, in this lady's case, be really important to understand whether the treatment itself was provided in a Cypriot hospital, as some hospitals in Cyprus, like those on British Army bases, they're technically British, so those claims are brought against the Ministry of Defence. So I think she'd need to get some really specialist advice about the sort of jurisdictional issues relating to where the treatment took place, but also just to discuss the specific facts, because it's difficult to really understand whether those fistulas have been developed as a non-negligent risk or because of a negligent error that's arisen.
That's great information. Would this lady be able to write to you and give you some more information? Would that be okay?
Yeah, absolutely. I'd be more than happy to review anything that she would like to send across, and I can have a discussion with her about it.
Fantastic. Thank you so much. The next question, it's such a very broad one, but one we get asked an awful lot. And it's to do with informed consent, and is not seeking informed consent for medical negligence. And I suppose we should really start by defining what informed consent is. It's about weighing up the risks versus benefits of the intervention, of any kind of examination or intervention, and also what would happen if you did nothing, isn't it?
Yeah.
And affording the person with all information and not just saying, because we hear of people being coerced, sadly, quite a lot, into various inductions. You must have an induction of pregnancy, and they say, I don't want to. And quite often, I don't want to use it, but there is sort of a heavy intonation towards what risks may occur if they don't go forward with the induction. And so it's a really difficult area. So what is informed consent and is not seeking it as negligence?
Well, before I go into it, I think it's very difficult, and I think a real balancing act, particularly I think in obstetric cases, because you're dealing with women at a very vulnerable time, often in relation to very sensitive and intimate parts of their bodies. And I think there's a real balancing act on the part of clinicians that needs to be made to get it right, and trying to sort of understand what significance an individual would place on a particular risk. But ultimately, if informed consent isn't obtained and a patient suffers an injury as a result of treatment that they wouldn't have wanted if they'd have known all of the relevant information in advance, then there might be a claim. And these cases can be very difficult. And I think the area of law relating to this is complicated. But we know that a patient should be told in a way that they can understand the potential risks and benefits of treatment and what alternatives there are that are available to them. But that doesn't mean necessarily that a doctor has to explain absolutely everything. You might have heard of the Supreme Court case of Montgomery, which was from 2015, and that sets out the sort of legal test in relation to informed consent, and that patients must be warned of all material risks. So a material risk, so as I said before, is one that a reasonable person in a patient's position would attach significance to, or one that a doctor should be aware that the patient would attach significance to. So if a doctor doesn't obtain informed consent to treatment, then it's considered breach of duty of care to that patient and is potentially negligent.
That's really interesting. And I know we see so much of it. One of the most common emails we receive is relating to consent is that somebody received a vaginal examination and was told, oh, I just gave you a little sweet whilst I was down there. And that's not seeking informed consent.
No, it absolutely isn't at all, and probably quite shocking.
Mm.
In those circumstances, it really isn't. And I think that's a common situation that does arise. And I've certainly heard it a number of times from clients that have seen me historically.
Mm-hmm. It is a terribly difficult thing to navigate, I imagine, but that's really interesting. Thank you so much. And moving on from that question, we've had another lady write in who said, when consenting to a procedure, why do they write plus or minus, even though they know it'll include something else? Should they not be telling you more about the actual procedure, not just the top 3 complications and risks, for example? I consented in writing to a C-section, but nowhere did the form say, or was I asked, or informed in the slightest that they used an anti-inflammatory suppository. I found out in my notes months later and was told that's just routine. If it's routine with any C-section, why wasn't I told or asked? Someone stuck their finger in my anus without consent.
It's unbelievable. So I think a claim can only be made when a patient's been injured as a result of medical treatment. So in cases involving consent, the claimant needs to prove that they weren't informed of a material risk or reasonable alternatives. And that with that missing knowledge, they would have made a different decision and they would have avoided the injury. And that's a tricky aspect of these types of cases because judges often consider that patients who are unwell or they're in an emergency situation, which this might have been in terms of the example that this lady has given, are likely to accept certain risks in order to have treatment which has good prospects of helping them. But I think the point is all patients are different, and one patient, so as before, might attach more significance to a particular risk than another patient.
Mm.
And whilst a medical professional shouldn't be expected to detail every single risk, it's also not for that professional to decide what they think the significant risks are and whether the patient should take that into account when making the decision. So we know from the case law that these discussions, they need to be clearly documented. They need to outline what's been discussed with the patient, the risks and benefits, any specific questions raised by the patient, and the consent form needs to be signed with a medical professional having gone through the specifics with them. I think in terms of the suppository issue in this case, and I don't know the extent of the facts of the case and whether this was an emergency C-section, for example, being performed under general anaesthetic, for example, where there was possibly an immediate danger to the mother or baby's life. And if the mother was at that time incapacitated, for example, if she was unconscious, the doctors can proceed without formal consent. But the reasons why treatment's necessary should have been properly explained once they'd recovered. So I think it's tricky. So I think certainly advise that this lady seeks advice if there are any issues. But it's very different, I think. It's very difficult, I think, for clinicians balancing dealing with that emergency situation if that's what it was here, for example, or in other cases, but balancing that against a woman's right to autonomy and not to be subjected to degrading or humiliating treatment. I think it's very informed consent is extremely difficult as a premise, but in practice it must be incredibly difficult, I think, particularly in those emergency situations where time is often of the essence.
I think there seems quite rightly to have been some real psychological distress to this lady, as anyone would feel, by being, in quote, violated in that manner.
Absolutely.
And so I understand exactly what points she's making. Gosh, it is so difficult, but like you say, everybody has autonomy over their own body. And that should be put above all else. Another question, how your birth notes are used as evidence. This relates to, despite lying to cover their tracks, I was told by some staff members that notes may not be the truth, but will be used against me anyway, and there are no repercussions to them losing some of the information in the notes to support their case. Is this the truth? If so, how can future medical practitioners support the patient if the information they've received officially is incorrect?
So I think similar to the issues we've just discussed before about incorrect information being detailed in notes, I think in a situation where either a claim's being pursued or somebody's concerned about their medical treatment because of what's detailed in their records being incorrect, and then potentially being ramifications for what their treatment pathway might be in the future, as a result of those inaccuracies within the medical records, again, I'd recommend that individual has those medical records rectified or deleted, and again, make that request in writing and explain very, very precisely what they feel is wrong with those records and why.
I think there has to be a move towards better record keeping. I know my days, I think for 5 days of my stay in hospital post-birth, I didn't exist and it was blamed on clerical error. And I think there must be a move towards digitising hospital records, because it's not acceptable for notes to go missing seemingly on a whim on many an occasion, and we do hear this. So hopefully that will be something that the new government take forward, because we do hear notes not being reflective of people's experiences and just going missing far too often. And again, this is leading on to another question that you have actually covered: why one cannot demand untruthful and degrading notes made by a health professional to be removed from the record with annotation. So they would write to the trust.
Absolutely, write to the trust for them to be rectified, and the trust will ultimately then have a duty to report that to the Information Commissioner in terms of what's taken place. But I would just detail very precisely what's incorrect in those notes and why.
That's really interesting that the trust would have a duty to report that.
Yes, and to the CQC as well.
So no, there would be some follow up to it. It's not just we'll change the notes and move on. There would be.
I think that's absolutely right.
Brilliant. Thank you so much. Moving on to our next question. I was medically dismissed from my career when I was forced back too soon after birth trauma. Work doctor recommended treatment for my PTSD, but since it wasn't all work related, nor would my own GP fund it, I was dismissed. Were they fair in doing this? It was another trauma, losing my dream, long-awaited job, like fighting for my life. I also feel the signs were there in the run-up to my life-threatening, life-changing birth trauma.
Gosh, I'm really sorry to hear this about this lady. I think from my perspective, I think without understanding the full set of circumstances, it would be really difficult for me to advise on this. I think predominantly because it relates to an employment law issue rather than a clinical negligence one. As such, I think in this situation, I'd recommend that this lady seek advice from an employment lawyer, and she should be specifically thinking about maternity discrimination and obtaining advice on whether she's potentially being treated differently or even unfavourably as a result of her pregnancy or maternity.
How would she go about finding that lawyer?
So in a similar way to finding a clinical negligence lawyer, a good starting point is to go to the Law Society, who can provide sort of detailed lists of firms by practice area and by location. She could also do so by looking at legal directories, which detail sort of different firms within bandings. So Chambers UK and Legal 500 are other firms. And if she can do basic online searches. And I would always say to clients, a really good starting point as well is to look at consumer reviews, because they're really important in terms of understanding the level of client care that's going to be provided. So looking at, if for example she finds a handful of firms that she might want to consult with, it would be probably useful to look at something like Trustpilot or Google Review to get a feel of what a client's perspective of that firm's like.
That's absolutely brilliant advice. Thank you so much.
Okay.
There's another lady written in who said, I received extensive negligence throughout my birth. However, some events were evidenced and others weren't, such as the verbal abuse and basic medical services. I contacted a local no-win, no-fee firm and was refused their services due to the complexity. They did advise I continue as I would have a successful case. I unfortunately work a minimum wage job. I don't have those funds.
Okay.
So would that lead on to our next question? How can I find a pro bono that can effectively sue on the basis of medical malpractice, but also the other events that have caused me such great difficulties mentally and impacted my PTSD and postpartum psychosis? I was bullied, taunted, ridiculed, and excluded from care due to ageism and ableism. To me, that's a form of negligence, as a midwife should be caring. However, some of these incidents weren't reported in any fashion. I just still suffer with the consequences for years post the birth. What would your advice be? What horrible, horrible story.
Gosh. Okay, so I think taking them one by one, I think in the first situation, in terms of this lady, where some of the events were documented, and some weren't, and in relation to whether she continues, I think first of all, I'd advise that she seeks advice from a firm specialising in obstetric or maternity related claims. I think in terms of bringing any claim relating to verbal abuse, whilst this is completely unacceptable, it would be very difficult to bring a claim relating to that specifically, unless, as awful as that sounds, unless that abuse or any failure to provide basic medical care has caused or exacerbated an injury. So I'd recommend seeking advice. And I think should a firm act for this lady, the first thing they would do would be to obtain copies of her medical records. And again, where there is information that isn't detailed within the notes, that can be addressed, as we've discussed before, by writing to the trust to explain that those notes are inaccurate and why. And any firm, if they did act for this lady, would take a full, thorough witness statement. Now, in terms of what she said about funding a claim, it's highly unusual for clinical negligence firms to ask for monies up front. So where claims are funded, which is in the vast majority of cases by way of a conditional fee agreement, so that's like a no-win, no-fee agreement, any deductions from damages made by solicitors relating to, say, a success fee or a shortfall, that's done once the case is settled, which means the client shouldn't be out of pocket. So that shouldn't really be a barrier to this lady seeking advice in terms of not having money right now. So I would recommend that she does go and seek some advice. Now, in terms of the other issue about pro bono advice and issues to do with PTSD and negligence, again, it's very, very difficult, because to bring any claim, we need to establish that the breach of duty has caused or exacerbated a physical injury, which has led to that psychiatric injury. Again, I'd contact a firm for advice, and even if they can't assist with a clinical negligence claim, it would be really helpful to seek advice on how to make a formal complaint. So, for example, we routinely help our clients with NHS complaints, and we guide them through that process, either review their complaints, letters that they want to draft, help them with that drafting and reviewing responses with them. And also in that case, I think if the events took place 4 years ago, the legal time limit to bring a claim may well have passed. So on that basis, I'd recommend to this lady that she speaks to a lawyer as soon as possible.
That's a really good point, because it could be that she wasn't aware of it. So many of our members at the BTA, they simply don't have capacity. For that first year, they're in survival mode. And so there's no insight or capacity into what went wrong and how it might have been done differently. And they are literally just in getting through that hour mode. So that's really good advice. Thank you so much. And it comes again to the next question, and there's such a common theme here, and it's really sad, because can you make a medical negligence claim for birth trauma alone, even if I didn't suffer physical injury, but I have been left with a PTSD diagnosis due to the appalling treatment I was subjected to? I have witnesses, and this might be something different, who can testify to the degrading, cruel treatment from midwives and others in the room.
It is a recurring theme, and I think it's a common problem throughout the country, with particularly in light of difficulties with maternity services as we understand it. But I think as part of a clinical negligence claim for physical injuries, that would be the only way in which this lady would be able to recover, say, compensation or bring a claim for psychological injuries. So to succeed in a claim, she'd need to establish that there was negligent treatment and that it caused a physical and psychological injury in that case. And then the extent of the physical injury that she suffered, and a psychological injury which has been professionally diagnosed according to the sort of accepted diagnostic criteria. So it's very, very difficult. And I can understand why you would probably have a lot of your members who have these recurring themes and issues to do with very traumatic events that don't necessarily fulfill the legal test. And I think if there's uncertainty with some of those cases, I'd always strongly recommend that they seek advice.
Absolutely. And will solicitors give that advice for free for the first consultation?
Yes, absolutely. I'm sure pretty much all firms will take those calls and have a conversation with, I mean, we certainly do, and where we would speak to an individual, and if we feel we can't help with a clinical negligence claim, we would explain why, and we would always offer to assist with any NHS complaints if they want to go down that route or feel that they're able to.
That's a really positive thing, because I know the criteria for medical negligence claims is so narrow in terms of what you have to prove. And so knowing that if you can't pursue a claim, you can still have your voice heard in the form of a complaint is incredibly validating to me.
Yeah.
So we have another question here. We're whizzing through because Instagram only gives us a finite amount of time to upload a video. I'm so sorry. But doctors insisted on assessing my mental health because I refused to have vaginal examinations. They said I was a safeguarding concern and called the psychiatric team to assess me because I was simply asking for autonomy over my own medical treatment. The psych team, incidentally, said I was absolutely fine. Where do I stand on this from a legal perspective? Please, can you explain the legal implications of respectfully declining repeated vaginal examinations and being told that for this reason only, there was a concern about my mental well-being? I felt both coerced and threatened.
Just appalling from my perspective, and I'm very sorry for this lady. I think whilst vaginal examination is a helpful way to assess a woman's cervix, it's entirely acceptable for a woman to refuse a vaginal examination, and women must be in a position to retain bodily autonomy and authority in relation to what happens, to their bodies and treatment that they're given. And I think we all know that there are other ways in which a midwife can assess how far along a labour is, an obvious one being how strong contractions are and how often they're happening. And many women birth without vaginal examinations, and it's an individual choice. So I think on the basis of what this lady has said here, it sounds that, I don't know whether it was actually performed or not in this case. I can't tell from the question. So I don't know whether it was performed without of consent. So I think in terms of there being grounds for a claim, I don't think there would be grounds for a claim if no vaginal examination was actually carried out. But I think in the circumstances, this lady should certainly make a complaint if she wants to do so.
Great, thank you so much. It's the idea of being told that you're mentally unstable and a safeguarding risk because you are holding autonomy over your own body. It's terrifying to think that would happen.
Purely because you want to make a different decision to what they're advising. It's unbelievable.
It's frightening. Another one we've kind of covered, but just so I feel that I've given this lady a voice. How can you select a good legal firm for pursuing a case against the hospital? I need no win, no fee. How do you choose which one?
Okay, so as before, really, with what I'd said in relation to an employment law firm, I would always recommend going to a reputable practice. If this relates to a case relating to birth trauma or an obstetric case, go to a firm with an established reputation for bringing successful clinical negligence claims. As a starting point, you can get details of firms who specialise in that type of work from the Law Society, or organisations such as AVMA, who are the Action Against Medical Accidents charity. And again, I would strongly advise using consumer review sites to get a real feel of what client care's like. So go on Trustpilot or Google Review, and it will give you a good feel about what clients think about those firms, because client care is so, significant and incredibly important, particularly in these types of cases where clients need really strong support from their lawyer.
That's brilliant. Thank you so much. There are really amazing firms out there. I know I came into Hudgell's and did a talk on how to effectively offer trauma-informed practice to people coming in with birth injuries who've been through birth trauma, and to see the receptive nature of the solicitors there was just simply wonderful. So trauma-informed practice is such an important leap forward, and I'm so grateful to Hudgell's for certainly pioneering their way in ensuring their workforce work to that manner. So we do have a couple more questions that come in today. And this one, oh gosh, I can really relate to this lady. My question is, what's the best way to prepare for legal battle? Is there any suggestion how to get ready? How do I prove my claim if my hospital notes don't say the full truth? Also, is going to a no-win, no-fear lawyer worth it, or better to go straight to a solicitor?
Okay, so there are a number of things to deal with there. So in terms of no win, no fee and conditional fee agreements, they would apply to all cases, and law firms that have that type of funding would be firms with qualified solicitors working within them. So there doesn't need to be, so I think there's a slight confusion there. In terms of being prepared for a case and understanding how a case might go and what it's like being, a party to a clinical negligence claim, I think the best thing to do is have a very frank, if you have instructed a law firm and they are going to represent you, a good solicitor would have a very frank conversation with you to understand what you want to get out of the case, what's important to you, how you want to work and why, and to just really get a feel of what's happened to you and what things are likely to be triggers in the case, but to really explain the process. And I think in a very candid way. So the things that are difficult about being party to a clinical negligence claims, and the things that are straightforward. And I think having those conversations at the outset of the case, so there aren't things that an individual would be surprised by as the case progresses, is probably the most helpful way of dealing with it. So if you've got a very open solicitor who, your solicitor's ultimately always going to be on your side. That's what they're there for. But you want to have a conversation with them to really understand the process and the pros and cons of what you're doing, and for you to explain really how you want to work and how to operate. But in terms of, for example, the life cycle of a case and how long it lasts often depends on how a defendant responds, for example. So I think you just need to have a conversation with hopefully a candid solicitor who explains to you what it entails, but knowing what you want to get out of it and what support you need all the way through.
I think from my own lived experience point of view, it would be prepared for it to take longer than you would like. It goes on in a long time, even when it's moving quickly. And also be prepared for something that's potentially really emotive to you and feels huge to not really count towards your case, such as somebody being cruel or unkind. I was incensed that I had been subjected to that treatment, but it didn't contribute towards my medical negligence case. And even though that felt huge to me, it was negligible in terms of what was going on in the legal arguments. And be prepared as well for something that totally floored me. When you read your notes, your medical notes, that's fine. But when you read the legal take on them, be prepared for your heartache and something that's so emotive to you to be written in what I would describe as the emotion and make out. Anyway, we have just one more question. So it's post-birth. I was already severely traumatised. However, on the ward, I was given drugs I was allergic to. I'm allergic to penicillin, and they were penicillin derivatives. I have a red allergy wristband. A lot of my PTSD and feelings of dying came from trying to tell them I was having a reaction and them telling me it was just from my major postpartum hemorrhage blood loss and to get some sleep. Is that something worth taking further? I'm considering speaking to a lawyer, but I don't want to if I won't get anywhere, as I know it will set me back. Thank you.
Okay, so I think on balance, I would recommend that this lady does speak to a lawyer. And I think, if this lady came to me, what I would need to understand is the extent of the allergic reaction that she had, but also then how the PTSD has manifested itself. Given that there was a postpartum hemorrhage, which in itself would have been traumatic, but a solicitor would assess whether they think the allergic reaction has materially contributed to the PTSD, which from the description here sounds likely,
Yeah.
but obviously we need to know the real facts of the case. So on balance, my advice would be that this lady does seek, does speak to a lawyer at some point.
I think that's absolutely right. We do have one more question, Maria. Do you have
Okay,
time?
absolutely, Rachel.
Thank you. I have a question that's been going around in my head for a while. I suffered from HG in my pregnancy. Although I was never diagnosed with it, I was sick upwards of 10 times a day until 20 weeks, and then at least 5 times a day until 40 weeks. I repeatedly had my concerns dismissed by health professionals, even when I asked about vomiting blood and when my liver blood results became abnormal. I was given cyclizine at 14 weeks and dragged it out until the end. My labour was awful and no one noticed. I was keeping no food and fluid down, as I was in a room on my own. I ended up needing an emergency C-section. My daughter was trembly and very unsettled in the first few days. We got 30 minutes sleep the first night she was home, and aspirated on her vomit at 3 days old, so we were readmitted to hospital. At the time, they kept asking me if I was still taking citalopram, as they thought she might have citalopram withdrawal. The only medication I was on was cyclizine. I now know she probably had cyclizine withdrawal and that it isn't recommended as an antiemetic in the 3rd trimester, but none of the health professionals around me knew about this or informed me of this. I've been thinking about making a formal complaint, but I'm scared of them saying I'm exaggerating or making things up. I feel like I was gaslit for my whole pregnancy, though. I just kept being told some nausea is normal, but nothing about my experience was normal. I have been diagnosed with PTSD, and 15 months on, I'm still under the perinatal mental health team. I keep wondering if I have grounds to make a formal complaint, but I don't even know who I would complain about, as literally everyone let me down in some respect. I'm also worried about the repercussions of making a complaint.
I'm so sorry to hear this about this lady, which is what a terrible sort of series of events. Just from the physical issues alone that would be caused by that, in addition to what's happened to her with PTSD after having given birth and difficulties with her baby. I think absolutely she should at the very least complain in this scenario. And I think obviously she was receiving antenatal care. I don't know, because I don't know whether she was under the care of consultants at the time, whether she had consultant or midwifery led care during the actual pregnancy. But I probably would raise these issues with whoever was connected to her antenatal care, whether that was a community midwifery team, as well as any other midwives or consultants that she saw, if these issues were similar with everyone that she dealt with. And I think to do that as a starting point, and I think if she, and it sounds like this lady is very vulnerable given what she suffered. And I think if she needs assistance with putting that together, she should go and seek some help from a friendly lawyer that's going to be happy to put something together for her, or at least to do it with her. in those circumstances.
Thank you, Maria. That's so good to know. And it's really good to know that lawyers will help with complaints and they won't charge for that. This is something they do as part of their remit, just to
Yeah,
be.
absolutely. It's certainly important to us in our practice, that we will always, even if we're not acting for an individual, we will always help them with a complaint, in terms of whatever they need in relation to that complaint. And I think particularly when it's at somebody's most vulnerable time, and they might not necessarily, we when we review a case, we can take a step back and think of some issues that perhaps the individual might not have thought of in terms of being an issue with their obstetric care, that because of our experience, we might be able to help them with additional questions that they might want to ask about why, their treatment pathway was as it was, for example. But I'd certainly recommend that this lady makes a complaint.
Thank you so much, Maria. I can't thank you enough. I know this
It's my
is meant to be
pleasure.
an Instagram live, but may I ask if anyone does have any questions that have arisen from this, they can write to the BTA and we'll forward them to you because you've given such great advice. And I know that you would never leave anybody hanging and you'd be happy to.
No, of course, if anybody wants to get in touch, they're always welcome to contact me for any advice. But
That's
thanks,
brilliant.
Rachel.
Thank you so very much. It's
All
been a
right.
pleasure talking to you today. Thank
You
you.
too. Thank you. Bye now.